All right, MJ, how many people do we have in the?
The last few people look like they are joining from the waiting room.
Okay.
Got amazing turnout today.
And then we'll have some people joining as we keep going, because there's going to be, I know Stacy Shester from the California Attorney General's office is going to join us. It's 8 something a.m. there, so she's going to join us later. I need to look and see exactly what time she said she wants to go for her presentation. Hold on. Yeah, let me see Stacy when she wants to join us. All right, how are we looking, MJ? We slowing down on the?
Yeah, there's no one in the waiting room anymore.
Okay, perfect. All right. I think Stacy was 12:30. Okay. All right. Good morning, everyone. Thanks for joining us for this meeting of the Data Privacy Task Force. Today, we're going to be reviewing the children's language from SB 3. Thank you for people who had sent in some red lines ahead of time and some suggestions. We're going to go through. We have a number of people who are going to talk to provide their feedback. So we have scheduled to speak, and then if you have questions, raise your hand, and then we'll call on you. But I think we will start with Andy. Are you okay starting with Andy Kingman from the State Privacy Coalition?
I just need a couple minutes, Senator. So if you don't mind
starting. Yeah, no, that's.
Thanks. Sorry.
Michelle Lucan.
Yep, I can go ahead.
Okay, great.
So
to start, we have Michelle Lucan, the head of Connecticut's small but mighty data privacy unit of the Attorney General's office. So thanks, Michelle.
No problem. Hi, everyone, and thank you, Senator Maroney, for allowing us the opportunity to speak today. Senator Maroney reached out and asked us to speak about the liability standard for teens data. And I know some of you had heard these comments on a prior task force meeting. So apologize for the repetition here, but just wanted to state again that protecting kids and teens' privacy is a real priority for our office. It's an area that General Tong feels very strongly about. And when we had weighed in support of Connecticut's privacy law back when it was still in draft form, we said repeatedly that this was an area that warranted careful consideration, and we really needed to make sure that the law goes far enough to protect kids and especially teens as groups that are uniquely vulnerable to privacy harms. And we had flagged an issue that we think is a language issue that we believed would dilute the protections afforded to teens under the law. And that was the context there is that there was a last minute change made to the draft bill for the teens liability standard. And the way the law is currently worded, it states that controllers shall not process a consumer's personal data for targeted advertising or sell personal data without consent where a controller has actual knowledge and willfully disregards that the consumer is at least 13 but younger than 16. And that word "and" is what is significant here. The language previously included the word "or," so that the standard was actual knowledge or willful disregard. And so we pointed out that this and structure, which I think was inadvertent, sets a too high standard. It's a confusing standard. It's also a departure from other state privacy laws where you have this standard on top of a standard. And it does not exist in federal privacy laws or current federal privacy proposals. I know that Stacy from California will be joining. The last thing I wanted to note was that the switch that we are asking for back to or, the word or, is consistent with California's consumer data privacy law. So just wanted to reiterate that for the group, and thank you again for giving us the opportunity to speak. We think this is a critical issue and certainly worth addressing. Hopefully the group agrees.
Thank you, Michelle. And that was inadvertent, and the goal was to match the California standard, which is actual knowledge. And then it's not necessarily written with the actual knowledge, or I think they say that someone who willfully disregards is deemed to have actual knowledge. So it's the same effect of actual knowledge or willfully disregards, but if someone wanted to match that specifically. I know, so as of July 1, you'll be charged with enforcing the language, right? The data privacy. I think, I don't know, and I don't want to put you on the spot, so this is something it's something I've been thinking about, so maybe you could send us suggestions to make it easier, since you are going to be tasked with enforcing it. If I don't know if it would make sense for us to give an including but not limited to, like willfully disregarding someone is the age of, includes but not limited to, or some examples. Or if that would hinder enforcement, or how you will, if there are ways that, because there are no examples from California yet. I believe their only enforcement, and we're going to ask Stacy, is on Sephora, and it wasn't on the age, it was on other issues. So I guess in just trying to provide some more certainty to companies for how to comply, if there are ways that we could give examples or define willfully disregards.
Senator Maroney, I think if there was any language you wanted us to take a look at, we would certainly look. Just off the top of my head, I would caution that it is difficult, I think, to define these standards neatly. I think there does need to be some flexibility on our part to determine what does this mean. And I have seen prior efforts to draft definitions in this area that have created more ambiguity between the different terms and may muddy the waters more. I think we could certainly look. I think the language, and just to be clear, this change to the word or would comport with California's law.
Correct. That'll match us with
consistency. It was a main goal of this group, and our language request is intended to honor that. I am concerned with the idea of adding language that would create discrepancies amongst the laws. And yes, it would be helpful if it was easy to provide enforcement examples to provide more clarity around the law, but the law hasn't taken effect yet. We haven't enforced it yet. California is still, it's still in the early stages of California's enforcement. But as I've said to this group in the past, that is something that we are mindful of. And I do think we have always tried to be transparent about our enforcement expectations. That will continue. And I would just caution against any additional language that creates an inconsistent standard from California or any other states, frankly, on this area, or language that might end up having the opposite effect of the intent.
Thank you. And for people who are listening, and I know we have some legislators joining us today who haven't listened to all of the task force meetings, that had been the standard in California since 2020. and the age of up to 16, I believe, for the children, and that's what will be our standard as of July 1. We're looking to go to 18, which California has passed and will as of next year, I believe. It's July 1. They have to promulgate their regs for this year, and then they go in effect their age-appropriate design code of July 1 of next year. Okay. Does anyone else have a question? And then I don't know if you had, well, I will circle back then, Michelle, with other questions as they come up. Let's see. Next, I will see is Nicole on? Yet. So I guess not for Nicole. So we'll hold off. Nicole Rocha from Five Rights is also going to present. David?
I'm here. Yep.
Okay. Are you ready to go? And do you need to be able, do you want to share the screen or?
Yes, I'm ready. And yes, I would like to share the screen. It looks like I can, so I can go ahead and do so.
Great. Thanks, David.
Sure. Imagine you can see that.
Yes.
Okay. So, Senator Maroney asked me, I'm sorry, my name is David Stauss. I'm a partner at Hutch Blackwell in the Denver office, been part of work group for the past couple of years. Senator Maroney asked me if I would give a brief presentation on two topics. One is the current status of children's privacy bills in the current legislative session. And the second one is just a brief overview of the Net Choice lawsuit against the California Age Appropriate Design Code Act. What I'll say is, the ask was to keep it to about 5 to 8 minutes. And so obviously it's going to be very, very high level in that regard. And I do apologize in the front end. I know there's people on here who know this stuff. They know it better than I do. I'm not going to dispute that by any stretch of imagination and know this in far more nuance. And so you're going to be left unsatisfied by the high level summary. But if you please indulge, just to give everyone kind of an understanding of what's going on. With the current status, I mean, I thought about just maybe having like a picture of like a dumpster fire or something like that on the current status of children's. There's a lot. I mean, I don't mean to be, flip about it, but there's just a lot that's going on right now. And really the genesis of it, I think, was California passing the Age Appropriate Design Code Act last year, which is really sort of this jumping off point. What we've seen this year in the Children's Privacy Bill land is we've seen Age Appropriate Design Code Act like bills. So we've seen those in Oregon, Nevada, New Mexico, Minnesota, New Jersey, and New York. My understanding is the Minnesota one, at least as of yesterday, I think there might have been some movement on it yesterday, but it was part of an omnibus finance bill at the point in time. And so there might be some updates on it today that I haven't heard of or as of last night. But the other bills, I think, are quiet right now. New York, I think, has a longer legislative session, so maybe something pops there. Another variation we've seen, though, is the social media privacy bills. So these are the ones that really go after like social media companies, and they say things like, you have to be over 18 to open up an account, or you have to have parental consent, those types of things to open up an account. And so we've seen those in the states listed here. I have a couple of slides after this. The states that have passed them so far are Utah and Arkansas have passed social media bills. And I'll go over those in a second. There's some other bills that are sort of floating around. Texas, a Texas bill got out of the House, I believe last week or the week before. And it looks like maybe there's some momentum in one of the Carolina bills. And then there's sort of like the other bills that are, some of them still alive. I mean, West Virginia, Virginia are not alive. Massachusetts has a long session. I think the Illinois one is not alive either at this point in time. Obviously, all this stuff is subject to change. The legislative process is incredibly uneven. In Florida, I think what I can basically say is something happened yesterday in Florida. A bill passed in Florida. We're still trying to figure out what that bill necessarily says, given that there was a flurry of amendments at the last minute. But my understanding is that there is some children's online privacy provisions in that bill. And I would say just, stay tuned as, law firms try to unpack it and we get the final, it's a larger bill. It's got like comprehensive aspects in it. And it's got some other aspects in it as well. But there was, I think it flipped both chambers yesterday and their legislative session closed today. So it was, House, Senate, House. So it was a really kind of a rapid fire. So on the social media bills, I'll talk about those and I'll just give you an overview of the AADC after that. Utah passes a social media bill, two bills, I should say. And this is one of them, SB 152. Minors, and that's under 18 years of age, can't open an account without parental consent. And then parents actually also have to be given access to their account to view their children's posts or messages. And then there's also some prescriptive requirements. For example, in the second to last bullet point there talks about, you can't use, minors have to be cut off from using social media account from the hours of 10:30 p.m. to 6:30 a.m. I think the idea there is that idea of like kids being on their social media accounts in the middle of the night type stuff is kind of the idea there. And there's also prior right of action in force that will go into effect there. The second bill, HB 311, is the concept here is that a social media company can't use a design or feature that would result in a minor being coming addicted to the social media platform. There's also private right of action. That's what we're seeing in these social media bills is private rights of action. And there's also a rebuttable presumption that harm was caused. And so some really different variations of the social media bills here. And to kind of add the last one piece to it is the Arkansas Social Media Safety Act passed after Utah. It's a slightly narrower bill than Utah. Again, it's got this prohibition on opening up social media accounts if you're under age 18. There's age verification requirements as well. Again, prior right of action, and which is what we're seeing on these bills, and that's effective September 1st, 2023. And like I mentioned, there's a few other states that are considering these social media bills as well. And, the scope, I've called them social media because it is like the definitions matter. I mean, you'll look at like I think even the Arkansas bill, I think you look at the bill and it's like 2 pages is the definition of social media company. It's an incredibly long and complex definition of it. And so there's a lot to be unpacked on these bills. I do not mean to suggest that this is everything on one slide about what's happening in Arkansas. Senator Maroney also asked me to address the Net Choice lawsuit. Again, very high level. There's been a lot of briefing. There's a lot of issues on this case, but just to kind of give everybody kind of an understanding of where it stands. The background, the California Age Appropriate Design Code Act was enacted September 15th. That's the date that the governor signed it. It'll go into effect July 1st, 2024. So there's a little bit of a lead up time. And it applies to the standard for application there is businesses, and it uses the definition of business from the CCPA. So that's that 25 million annual gross revenue, 100,000 consumers of collection or data broker. So a business that provides online services, products, or features that are likely to be accessed by children. And that's a term that's defined in the statute. And it has, I think indicators is the word I believe it's used. And there's a number of bullet points about what would be likely to be accessed by children. And again, this concept of children is under 18 years of age, which we saw in the Utah and the Arkansas bills as well. What do you need to do? Again, not going to go over everything, but just to hit the kind of the points, in particular, the points that are really being addressed in the litigation. You need to do a data protection impact assessment. So conceptually, we know these from like the Connecticut Data Privacy Act, but here it's this, analysis of your online product, service, or feature. They require 8 factors there. I have not listed all 8 factors because you would kill me if I put that all on the slide. So what I put there, though, is the one that I think has been kind of pointed to the most in the litigation, which is this idea about whether the design of the product, service, or feature could harm children, including exposing children to harmful or potential harmful content on the online product, service, or feature. And that's kind of a phrase that's really been seized on in the litigation. And then the concept there, the last bullet point, for lack of a better term there, is that you've got to document the material risk to children, and then you've got to create a time plan to mitigate that risk. There's more in the DPIA section that's going on, but that's just, again, high level. Some additional provisions that are part of there. And again, there's more provisions in this, but kind of the ones that are being challenged in litigation, I wanted to tease those out. age estimation. So this is that concept of like, how do you know that someone who's under the age of 18 who shows up on your online product, service, or feature? You would have to perform some sort of age estimation. And this concept is I think, one that's being talked a lot about by law firms and providers right now. There's a difference between age verification, like presenting a driver's license or, COPPA, parental consent type stuff, where they actually verify that it's a parent. Age estimation is and other people have a better explanation than I do, maybe. Would be happy to listen and learn. But aspects like, and talks a lot about, like, you could use facial recognition, right? And so the facial structure of a 43-year-old prematurely gray male, for example, in Denver, who's a privacy attorney, looks a lot different than the facial structure of an 8-year-old child. And so, like, you could use facial recognition to estimate the age of a child, and that raises issues, or in litigations, it's raising issues in litigation. Default privacy settings. So the concept here is, if you don't know the age of the child, you should have, or can't estimate the age of the child or the person who's showing up on your online service, product, or feature, you should default to the highest level of privacy settings there. And then the third one, age appropriate disclosures. The concept there is, we write privacy notices all day, every day, right? And they often tend to be dense and legalese and all that type of stuff. And the concept there is, well, you should write your privacy notices and other documents like terms of use and those types of things that are appropriate for children, right? So, but that becomes, conceptually, I think, the issue there that people have identified, and not to say what's right or wrong by any stretch of imagination, but just to present it, is to say, what does that mean for a 4-year-old versus a 17-year-old, right? That sort of spectrum of, like, what would that documentation sort of look like? So the litigation, and this will be, you'll be happy to hear, this will be the end of the presentation, is the litigation aspect, is the complaint. NetChoice filed a complaint. I do want to say, because, haven't connected the dots here very well, but those Utah and the Arkansas bill, everything we hear is, and what we expect is, those also will be challenged on constitutionality grounds. We don't have those complaints yet, but I think we expect to see them in the community. Honestly, I don't think that that's inaccurate to say. And so what I'll say is, in the next couple of slides, I'll go through a couple of the arguments being made, and I think just conceptually understand that, like, the same arguments that are being made against the Age Appropriate Design Code Act could, and some of those could be made against the Utah and the Arkansas bills as well, those social media bills. So the NetChoice lawsuit, and again, there's others on this call with much more familiarity, but just on a high level, it's filed in December in federal district court in California. There's been a motion for preliminary injunction that's been filed. So that would be, the concept there, for those unfamiliar, would be, court, would you please enjoin the law from going into effect on its effective date, right? And then while we go through the process of deciding the merits of the lawsuit, would you stop it from going into effect at this point in time? And so that was filed in February. The opposition was filed in April, and there's a hearing scheduled right now for July. There have been many amicus have been filed as part of it. There's been a number of briefs. This is just the entities that are attached to the docket as being amicus in the case. And I think the reason I pointed this here is to say, there's a lot of people who are very interested in the outcome of this litigation. It's very, very heavily litigated. A lot of thought leadership going into the briefing in this case. The NetChoice arguments. I've got 2 slides on this one. And I should credit, I did a panel with Tyler Newby at Fenwick, and with his permission, I kind of repurposed his slides from these next 2. And so this is a lot of Tyler's thought process here and work product. But, the arguments, and there's others, but just kind of high level aspects of this, vagueness. So some of these terms we talked about on those introduction slides, like material detriment, harmful, and harm, the arguments there have been, they're not defined in the law. And so that creates vagueness issues. And then the age verification requirement as well, they're claiming that has some vague language as well. And the dark pattern prohibition is vagueness issues as well. There's other arguments on the vagueness, not suggested there isn't. And I should say as well, the contrary argument from the Attorney General's office is basically everything that NetChoice says we disagree with. Hold on a second.
Last time I had that much wine before I...
Hey, Patrick, would you mind muting yourself?
I did.
Oh, well, I'm almost done. So, the First Amendment issue, I think, is in my mind is kind of the most live issue in the case. Not to suggest the other ones aren't, but I think there's been a ton of briefing on this, and it's really kind of very interesting. Frankly, I read through this First Amendment issue.
Hold on one second. Hey, Pat McCabe,
That Palm Margin.
would you mind muting yourself? MJ, can you mute? Okay, great. Thank you. All right.
So, I mean, if you're a First Amendment scholar, there's a ton of really interesting arguments on the First Amendment stuff. There was in particular an amicus filed by a law professor that really goes into these issues. And that goes back, as you may recall, I had that one bullet point out that had that one of the 8 factors was content, right? And that really is the heart of the matter, is the argument over whether this is a content regulation bill versus a personal data bill, right? And so you see that in the briefing going back and forth about that exact issue. And then you see also mentioned, at least in the amicus brief with respect to the law professor, about whether there's an existing United States Supreme Court case, Reno versus ACLU, that really I think is kind of relevant to the analysis here and goes over some issues as well. So again, high level, not trying to get into everything. The COPPA issue is the arguments there are that you can't conflict with COPPA for under age 13. You can't, and then the issue is, well, the language, the preemptive language in the COPPA statute, how has that been interpreted by courts? There's actually very little case law on that. There's a couple of circuit court decisions about like how much can the state do vis-a-vis COPPA. And I think that's a live issue that will be teased out with respect to this one as well. And there's also a secondary argument that talks about when Congress made a decision to regulate under 13, that it did field preemption. And so it also made a decision that, 13 to 18 should not be regulated conceptually there. The Dormant Commerce Clause, the concept there is, a state can, regulate within its borders and not cross-border traffic. And then the Section 230 issue, one of the last amicus that was filed had a lot of discussion on Section 230. But again, it's on the bullet point there, but the statute would conflict with an operator's rights to take good faith actions to restrict access to harmful content. Again, this is only to suggest that these are the arguments. Obviously, this is all very live. Courts will be deciding this, in the very near term. I think I would expect to see something in the summer, early fall on the decision. But again, other people on this call might know a heck of a lot more than I do. But yeah, Senator, that's it. If you had any questions.
Yeah, we actually have a little more time than when I told you. So I'm going to ask a question on, a few questions. So obviously the vagueness argument, does that open up our SB6? Because a lot of the terms you mentioned were terms that we had used, the dark patterns. We have risk of harm. There had been, someone who had suggested we add that material risk of harm, instead of just a risk of harm, and doing those assessments for, at least for the children. So I don't know, how does that open us up for arguments? And again, anything can be litigated, right? We know every law can, there could be challenges too. So it's not going to prevent us from doing it, but just to try to, if there are things we need to do ahead of time to address that. And then the other is if you could just go into a little bit more, why how the Reno versus ACLU is applicable, and what are the ramifications for that?
Yeah. So easy questions you've asked today. So
yeah, you know me, I like to give you layups.
How does it affect SB6? So SB6 is the Connecticut Data Privacy Act. I mean, I would imagine, just SB3 is the bill you're running. Did I have that right? SB3 is the bill we're running this year.
Yeah, this year.
Last year, right? So the question is, how do the arguments in the net choice case impact, if at all? It's a fascinating question, right? And it's not just an SB6 question, right? It would be a Colorado and Virginia and Indiana and potentially, well, Iowa and Utah don't have DPIAs in them if those are provisions. So it is kind of a fascinating question, right? I mean, it could have I suppose it could have ramifications across the board. I hadn't really thought too much about that. I hope it doesn't, given how hard everybody's worked on trying to get privacy law at the state level. But I suppose we'll just have to see. I would think, I don't know. I would think that, really the DPIA requirements are, I think, live, right? I mean, there's that's really been a feature. If you read the briefing, and the briefing's been very good on both sides. Not to suggest otherwise, it's been very good, and it's going to be a tough fight there. But there's a lot of focus on the data protection impact assessment and exactly where the contours of that goes, if it's content versus personal data and those types of things. And there's really like live concepts there that need to be, and those could, I mean, to answer your question, Senator, I mean, those could in theory spill over, I guess, into general data privacy law. I don't know. I probably have already gotten well over my skis on that. I should probably just stop. It is kind of a fascinating question. But yeah, I mean, you use, in SB 6, dark patterns was used. The Colorado Attorney General's office has done some work around dark patterns. The California Privacy Protection Agency as well. The FTC has done work around dark patterns as well. So, and I think it's also one of those things where you have, in litigation, you kind of have to see what the court decides it on. The court could decide it on narrow issues, or the court could decide it on larger issues and not address all these sub issues. So, I think what we can confidently say is, in the next couple of years, we're going to know a heck of a lot more than we do now about the contours of how, if at all, states can regulate in this area. And I think that's what we do know. You also asked about Reno versus ACLU. So the nature of that case is the statute is COPA, a predecessor statute to COPPO, the Children's Online Privacy Protection Act. Was a first attempt at regulating in this space, got challenged and was struck down as being unconstitutional. And I think, the language that has been focused on in the briefing, at least in the law professor brief I mentioned before, was around this concept. The Supreme Court was saying that you can't take the internet and distill it down to what's acceptable to a sandbox, right? So it restricts speech if you restrict the internet down to what's acceptable to a 4-year-old, basically, to paraphrase. And so I think conceptually that's a live issue that the courts need to kind of work through in the NetChoice case, about whether any of the provisions. I'm trying really hard to walk the line. I'm not saying it, but trying to present the case fairly and not to slight it all. I think it's a live issue. In that case about the application of Reno versus ACLU and whether whether that precedent from the United States Supreme Court, the impact it'll have on the Age Appropriate Design Code Act. And obviously people feel very passionate on both sides of those issues.
Now, does that have implications for the social media ban as well? So for the Utah and Arkansas with the Reno versus ACLU, and then another law you hadn't mentioned, but the Louisiana law, which requires uploading of state driver IDs to access porn. And then how is that, what is the basis? Why is that different than the other age verification?
Yeah, so from what I've read on, and again, so the Utah bill passes earlier this year, the Arkansas bill passes earlier this year, and these again for those who, just to backtrack a little bit, those are the bills that apply to social media companies, and they say things like you need to have parental consent if you're under the age of 18 to open up a social media account. They do other things as well. I was said in a slide deck as well, like giving, at least the Utah bill gives parental access to communications and those types of things. From what I've read, and the cases haven't been filed yet, but from what I've read, the arguments are going to be very similar around the First Amendment issues. And they're going to be, so the arguments are going to be primarily around the idea that it restricts speech, it restricts minor speech, it restricts access to online content. There might be others who are much more fluent in those issues. But I do think that the argument is going to be around that Reno versus ACLU case as well, to foreshadow and guess at where that's going to head. Is they're going to say like, hey, I think what the the individuals who believe that the law is unconstitutional are going to say that they believe that it violates Reno versus ACLU, that you can't restrict, minors in that way. I think there's going to be arguments around COPPA as well. That, the things we talked about before about, it conflicts with COPPA, those types of issues. Not to suggest the answers to those questions, just suggest that I think that those are all the same arguments that are going to come up with respect to those. And those are being said even before the governor of Utah signed it. There was a lot of Twitter action about the constitutionality of the bill, those types of things. So.
Right. Are there any questions for David? Again, if you have a question, please just use the raise hand feature and or message, and then we'll call on you. So I had another question that kind of, that I lost it. So if I think of it, I may ask or reach out. Oh, would you be willing to send us your slide deck so that we could share that around?
Yes, no problem.
And then I do see Andy has his hand raised. Andy Kingman.
Yeah, Dave, thank you for presentation. Very helpful as always. I was curious, could you just spend another moment on kind of the amicus briefs and who submitted those? Because I think that was one of the things that I was struck by, is that, there are a number of civil society groups who are sort of participating in this as well. And just curious for your thoughts on that.
I'll put the slide up again. I just went to the docket and just did a listing from top to bottom. I think Andy, what you're really getting after and what you really wanted to talk about was the fact that the Prince Harry and Meghan have joined in an amicus. I think that's
look, it's coronation weekend. I just think we should do as many tie-ins as possible. I'll be up at 5 a.m. So yeah, let's dive in.
Full regalia, I can imagine.
Absolutely.
Yeah, I mean, what I would think. Here's what strikes me. And listen, I want to really walk a line by just trying to be as neutral as possible on this stuff. These don't necessarily line up with where people may think they line up, right? These organizations might be on opposite sides of what you would necessarily think they would be on. And so, there's obviously, there was a large number of organizations, including Archwell Foundation. That's the organization I was referring to with Prince Harry and Meghan. You guys know this already. That attached themselves to a brief that was filed last week as amicus. And then there's been, obviously on the business side, the Chamber of Commerce has filed one. And then Eric Goldman was a law professor I've mentioned a few times. I should have had that committed to memory. Apologies. Who filed the one on the First Amendment issues as well. So, I think some of these organizations, they really kind of fit in where you think they would, but maybe some of these organizations don't. So I don't know, Andy, that answers your question, or if it just, I think for me, the reason I had this slide here was just to show people that, it is a very live issue in California. It's a very, there's a lot of people engaged.
You really deserve it. This is where everyone's from.
Yeah, that does. Thanks, Dave.
Right. Yeah.
Okay. Are there any other questions for Dave? All right, David. Thank you very much for that update and for taking the time. And then just a reminder to everyone, if you're not muted, you may want to mute yourself, except for the speakers. So, Andy, are you able to go now?
Yeah, absolutely.
Okay, and then do you have a slide deck or? I don't.
Okay. I'm just going to kind of run through some high level issues that we've got and some feedback here, and we'll go from there. Again, happy to take any questions as we're continuing to work through this. Obviously, I'd much rather be talking about the coronation, but
or your new house. Congratulations!
Thank you. Okay, so I think our my feedback today is going to be a little bit more kind of granular in the weeds. So
Great.
Happy to, again, answer any questions on that. First of all, appreciate it. I noticed, obviously, a lot of our feedback has been incorporated here thus far. So really appreciate that. A couple definitional pieces that still are causing us some concern. I thought that the gender affirming care definition and crosswalking it to that statute works pretty well. I think our question, there's also a reproductive or sexual health care services definition in that same statute, reproductive health care services. And so, I think that it includes all medical, surgical, counseling, or referral services relating to the human reproductive system, including but not limited to services relating to pregnancy, contraception, or the termination of a pregnancy. So, I think one of the questions is like, would it be possible to just crosswalk both of those since they both are defined and we're both getting in there? And then to that same point, I think I would still love to see the definition of consumer health data be just those two, given that, again, health conditions or diagnoses more broadly are covered by sensitive data, are already in the sensitive data definition. And so I'm not sure, I think we want to avoid creating overlap there. And so would just suggest that we keep that in there. There was a new statutory reference to the status as victim of a crime that was in there. And I looked up the reference, and that status as a victim of a crime also includes immediate family members of a minor, incompetent individual or homicide victim, and a person designated by a homicide victim. I'm not sure, I'm just curious how you kind of were envisioning, Senator, that working, or how a company would necessarily know, not just that somebody has been the victim of a crime, but also that it could be somebody who is connected to that victim.
Yeah, and that's so we took that from the Oregon statute. Right. Like when Oregon was going to do a version of our bill, they had added into the definition of sensitive information, and it is something, especially when we're looking at domestic violence and trying to protect victims of domestic violence, that crime status. I don't know. I don't know if Michelle could weigh in from the AG's office, because they had also helped to flag the Oregon definition of sensitive.
Yes. Yep.
I don't believe that they had a statutory reference to it. It's just status. Right. Sorry, go ahead, Michelle. I didn't mean to interrupt.
Right. That's actually exactly what I was going to say, Andy, too. We did flag that, and the idea was to make sure we were keeping up with expanded definitions for sensitive data, which makes sense. And I wasn't aware of any discrepancies that our language created within the framework of Connecticut law. So we could take another look at that. So I don't know off the top of my head, but the idea was to make sure we weren't enacting this and already being a step behind. And I think all of these data elements are really important and do make sense to be included in the definition of sensitive data. But obviously, if there's a ripple here that I'm not aware of, I think that this group.
Yeah, I think it's just that, sensitive data obligations trigger opt-in consent requirements, right? So it's just about how the controller would know necessarily, not that someone was the victim, I mean, not just that someone was the victim of a crime, but since the definition of the victim of the crime includes immediate family members of a minor, that there's some ripple effects there that I think could be really difficult from a compliance standpoint. So that was sort of the last definitional issue that we've got. I think the single biggest thing in the health data section that we're very concerned about is the consent requirement for employees, processors, etc. So this is in section 2, A1, that would require consent or prohibition on providing any employees with access to consumer health data unless the consumer consents to providing such access. I think, I think there's a real expectation among consumers that if we are providing consent, that employees would then have access, or that information may go to processors or subcontractors. And under the underlying statute of SB6, there are already pretty strict rules of confidentiality and contractual limitations on what employees and processors, could do. And so adding another opt-in consent barrier, or having an issue where somebody consents to the collection of that but doesn't consent to providing an employee or processor with that information, I think is pretty problematic, and I think that's a top level concern for us there.
Now, I do believe we have, doesn't it say, or if it's necessary to provide the service that's been requested. But would it be if I'm just trying to think of another way what we could put in there in terms of if you're already complying with.
I mean, I think we could. I think we could cross-reference it to SB6 and say, no, like a consumer health data steward shall comply with the requirements of, the employee confidentiality section and the processor contractual requirements section, something like that.
Okay. Yeah.
But I think
would you mind sending language on cross-referencing it?
No, that's fine. I think we want to make sure that there's not an extra opt-in consent barrier for something that, I think consumers would sort of normally expect anyway here.
Okay.
One of our suggestions is to move the geofence to 1,750 feet. Not for
I agree.
Practical, just so that we don't have different measurements
definitions between the precise geo.
Exactly. Yeah. And obviously they're slightly different. But...
It's been bothering me, but I didn't change it because I
Yeah.
I would like to do that as well. So okay.
I think particularly if the definition of consumer health data is not changed to just include reproductive health care and gender affirming care. In the right to cure provisions that lay out criteria, I think it would make sense to add in the sensitivity of the data in terms of the criteria about the Attorney General, being able to consider the ability to offer a cure. Again, if we're talking only gender affirming care and only reproductive health care, then that probably is a more moot point. But if we're going to keep it broader, then I think, there's going to be any number of data elements that are not particularly sensitive.
Okay.
And so we would just encourage that. Going back, so those are basically our healthcare data feedback as of right now.
Okay.
I would just stop and ask if anybody has any questions before we dive into children's stuff.
Can I ask a question?
I think we're getting there. Yeah, go ahead.
On the geofencing, and you may, what is the difference between saying you're prohibiting the geofencing of a location versus geofencing of a person?
Well, I think the location would be far easier to work with, right? Because that location doesn't move. Right. And it's probably way more pro-privacy, because if the geofencing of a person is what we're talking about, then you have to know their location literally at all times, right? So I don't know that we necessarily want to get into that.
Okay. Yeah, no, I had assumed a location.
Yeah.
And I didn't know if when the language of a person would mean that, because I know in sometimes, I think you can advertise based on where someone's been, right? Versus, I think if you're preventing, but that would be if you prevented geofencing location, then you couldn't show ads to the person that had gone to that location because they had gone to that location, right? Or show them specific ads while they're in that location. So I think that for what our goal is, I think that the location gets it, but I'm just trying to understand. Have requests.
I think we would be pretty uncomfortable with suggesting that you've got to, have a basically traveling 2,000 foot or 1,750 foot, circle around you at all times, right? So
okay.
And I think that would be disproportionate to the use case that we're trying to get at, right? Which is
right. So
if people are going to, reproductive care clinics, et cetera, they don't want to be getting bombarded with text messages or ads trying to convince them not to seek those kinds of services, right? So,
right.
Okay. So in terms of the age piece that we've been talking about here, the actual knowledge versus willful disregard. I was thrilled to hear Michelle say that they were just looking for consistency with California, because the willful disregard standard in California is only from 13 to 16 or under 16 in the CCPA. The AADC does not have a willful disregard standard.
Okay, age estimation.
And so that just defines a child is under 18. Now, I still think that, I think we still feel like under 18 is too broad and would like to see that move to 16. But I think it is important to understand that the CCPA, which is sort of the general data privacy statute, has willful disregard or actual knowledge from 13 to 16, but the AADC does not have a willful disregard standard. I just want to point that out. Again, I think we would much prefer an actual knowledge standard to really, again, try to minimize the age verification. I think to that point as well, I'm not sure that the new adult definition does anything other than create more incentives for more age verification, because if you're creating other barriers to, sort of messaging with people, et cetera, you're going to have to make sure that somebody isn't 21 or is under 21. It also, the way that this is drafted, kind of has a donut hole. So you've got under 18 or child, and then over 21 is adult, and then there's nothing for 19 or 20-year-old. So, I don't know that necessarily, advances the policy purposes of what we're trying to get at here. I think I would encourage us to look at starting on line 240 excuse me, that's not the right reference here. I apologize.
Okay.
Hold on 2 seconds here. Just trying to get down to the right section. Sorry. I've lost the thread here.
What was it?
But it's basically the consent requirements starting on line 631.
Okay.
I think it's fairly confusing just in terms of what is required where. There's just so many different sub paragraphs in letters the way that this is laid out. It would be helpful, and I'm happy to take a shot at it, but just clarifying how this actually all works together.
Okay.
Just because there are a lot of negatives and there are a lot of subject tos,
Yeah.
etc. And it's not totally clear to me how this is all intended to work together. So that's just more of a drafting piece than a policy piece. But having learned from California, drafting matters quite a bit in terms of obviously compliance. So would just sort of suggest that we take another crack at trying to make this clearer.
Yeah, and I'll speak with something. We're trying to match conventions of other statutes, and I didn't draft that, but the LCO I know. But I agree with you that it becomes unclear, subject to consent, and having the consent requirements coming after instead of just saying without obtaining consent or without opt-in consent right there, and then deeming what,
One piece in terms of harmonizing with SB6 is that an SB6 profiling is dealing with solely automated. And so that's something that I think would be helpful to just align with in the definition of profiling here.
I've written that down as a note. Yeah. So that is a change that I plan on making.
Okay, great. And then, I think the significantly extending time language is still causing our members some teeth gnashing here. And just trying to figure out what that actually looks like and what that would mean. I think in the AADC, the element there is an element of the data protection assessment. It's not an affirmative obligation, right? It's just a component of measuring the risk in the DPIA. And so that continues to be a concern for us. And then the messaging.
Would there be a way on that? Because there was a suggestion. One of the suggestions I received was to tie that to the risk, the extending time where there's an identified material risk, or in some way tying it back.
Yeah, I mean, I think I'd have to check with my members, and happy to kind of look at what would be the proposal. My understanding, and I am not a First Amendment attorney, so will not try to get too far over my skis here. But my understanding is that the problematic component of the AADC's data protection assessment is that it basically requires you to make content judgments, right? So I think if this was worded in a way that said, look, you have to weigh this, but we're not telling you what to do with it. I think that kind of threads that needle, but would have to check with my members on that.
Okay.
And then, again, I'm very sympathetic to the messaging piece here, because I think we all know what we're trying to get at, which is sort of the CSAM grooming, that type of activity on various platforms. And I think, obviously this is, revised language from the last draft. I think there's just, I don't know how companies would be able to know if the adult has an existing relationship or is reasonably associated with a minor, like what that looks like. And so I think that's still causing our members a lot of concern about how that would work in practice from a compliance standpoint.
Okay. And I'm looking at other language there, right? Because that's an important, I think that's an important piece of this, right? And for me, I'm not going, it's not something I'm necessarily willing to trade out, I think, but I do want to make sure we're getting it right. So looking at if you are providing a messaging platform as part of your service or something, then that's right, versus you're not, right, we're not looking to prevent, you can't prevent an email or other things, but if you're communicating within the platform, I have a few different, received a few different suggestions, and over the weekend I'm going to try to see how we can best combine them to get something that that works.
I think the stuff that we're thinking of is like coaches, teachers, in the offline world, it obviously would have an existing...
Teachers, though, would be that's a relationship that, and so
it is, but I'm not sure it would be obvious to the platform, right? The obligation.
I see what you're saying, to automatically block.
Right, exactly. In the offline world, of course, we know who your coaches, who your teachers are, et cetera, but a platform would not necessarily know that, right? And so how do you kind of balance that, I guess?
And I guess the pushback would be like, if you're a teacher, should you be contacting your students through a social media app versus email, a school email, or I don't know.
Yeah, I don't know either. Thankfully, I have a 5-year-old, so I am not faced with those questions yet, and happy not to be. But that's one of the things that's still causing us some angst. The other piece, the last piece I have here is a proposal for language that you and I talked about, Senator, that would be attached to Senate Bill 6. And this would, one of the things that we continue to be really concerned about is being either required or heavily incentivized to continually collect more and more information about users and their ages, particularly teen users. And so one of the suggestions we would have would be to amend SB 6. This is the language that says nothing in sections 1 to 11 of this act shall be construed to deal with de-identified data, but also maintain data in identifiable form, or collect, obtain, retain, or access any data or technology in order to be capable of A, associating an authenticated consumer request with personal data, and then our suggestion would be, or B, inferring additional characteristics about a consumer. To say, hey, if you're not already doing that, you're not going to be required to start collecting more and more data about your consumer. So that would be the other language proposal that we've had that you've got now here. So
yeah, and I have to think through that because we don't necessarily want to say to turn a blind eye to if someone is a minor, but I get it that we don't also, right? We define state government IDs as sensitive information. So we don't want to require people to take extra information that we consider sensitive. However, I'm not outright opposed, but I'm just trying to figure out, is that the right balance, right? That we're both trying to achieve. So, but I'll think that through over the weekend. And then back to the messaging, I do have a copy of one of the things that suggestions we received was to offer any direct messaging features to such minors without providing an option, controlling the ability of other individuals to directly contact a minor. So basically, if you had controls in there, I would only put something like that, provided the default setting prevented communication between an adult and a minor. So the minor would have the control to turn that off to allow for contact, but by default it would be set. I don't know. That's one other suggestion. Again, I'm going to weigh a few of the different pieces, suggestions over the weekend and come up with new language.
Okay. Okay, that's all we had.
Okay, great. And I'm going to ask people to hold their questions for Andy if you have them, because I did see Stacy is on, and I should know she has a tight window. So Stacy Chesser from the California Attorney General's office, thank you for coming on. And she's spoken with us in the past, and she's going to talk a little bit about, I guess, this actual knowledge or willfully disregards has been in effect, that language. So I've asked her to speak a little bit about that. And I asked you something else, and hopefully you remember what it is, because I don't have it written down in front of me. So thank you, Stacy.
Thank you for having me. And so I'm going to speak a little bit about the standards that we have in place to protect kids here in California. I'm a little bit restricted in how deep I can go into some of this because, as most of you know, we are in the midst of pending litigation that's being handled by a different section in our office, but we don't comment on pending litigation, and so not commenting on the arguments there. Although you can go and read the briefs that we have drafted and submitted to the court regarding the preliminary injunction sought in that case. Which probably gives you a bit more understanding of our process and our thought process on that. So I'm going to try to address your points, Senator Maroney, but I'm going to probably just frame it as I think it's helpful. Okay. Okay. So the CCPA, including as amended by the CPRA, which really didn't change the standard. As it relates to minors, specific, it says no selling or sharing of personal information if the business has actual knowledge that the consumer is less than 16 years of age. And I'm just sort of grouping in the 16 and, the distinction between 16 years versus 13 years because it's the same type of knowledge requirement. It also states that a business that willfully disregards the consumer's age shall be deemed to have had actual knowledge of the consumer's age. Willfully disregards isn't specifically defined in the statute, but I think that that's something that potentially could get litigated. However, I also in reviewing and sort of thinking about the questions that you had today, I think that the framing also in the AADC, in the Age Appropriate Design Code, could give an indication for ways in which the question of what is like a willful disregard of a consumer's age might be. So importantly, the AADC does not include the same type of knowledge requirement as in the CCPA. It instead shifts the burden from knowledge, right? So from a business having knowledge to require that covered businesses estimate the age of child users with a reasonable level of certainty appropriate to the risks that arise from the data management practices of the business. Alternatively, you can apply the privacy and data protections to all consumers. So if you cannot determine the age of your audience, for example, then you have to apply the requirements of the AADC to everyone. So the default then shifts. It's also built, this new standard likely to be accessed by children is built on existing standards or other legal frameworks that are currently at play in terms of how children's privacy is regulated. So in the statute, it says likely to be accessed by children means it is reasonable to expect based on following indicators that the online service product or feature would be accessed by children. It references COPPA, for example. So it's directed to children as defined by COPPA. It also says something relating to if it's based on competent and reliable evidence regarding audience composition. So like I read that and, I think about like the fact that there's metrics or analytics that could be available that could make, provide evidence regarding audience composition to the extent it's competent and reliable evidence. Another indication is if it features advertisements that are marketed to children, design elements that are known to be of interest to children. So that to me is also a little bit of a COPPA standard. So like including but not limited to games, cartoons, music, and celebrities who appeal to children. So I think that that's something that's also grounded in COPPA, as well as based on internal company research. So, if there is an enforcement case, for example, if there's an enforcement case, that means that, part of what the investigation would include is looking at producing documents regarding internal company research if there is a significant amount of the audience that the internal company research shows is children. With respect to enforcement, as I'm sure many of you know, California has been really active in terms of enforcing the CCPA. We surprised everybody when we hit the ground running on July 1st, 2020, and we really not stopped since that point. And what we've done in terms of, as you all know, before 2023, there was a requirement to issue notices of alleged noncompliance to companies and give 30 days to cure. And so in terms of pulling back the curtain a little bit and providing a little bit more guidance to the business community and consumer advocates about how we were, what these notices of alleged noncompliance looked like, and steps that businesses could take to address those allegations, is we posted a list of case examples on our website. I think we post at least 2 sets. And so I was, in trying to prepare for this, I looked back at potentially one of these enforcement examples, and there is one on there that refers to a fintech product that was for minors. And it was a specific product that was offering financial services to minors, including those aged 13 to 16. And this business operated a mobile app and had privacy policies and notice requirements that we alleged, were not compliant. And so you can go and take a look at what that specific case example states in terms of how this business, that clearly marketed its products to those aged 13 to 16, how, that would fall within, obviously that would fall within the question of you're targeting minors in that respect. And in addition to that, I can also say at a high level, we have done investigation work, including undercover work in connection with how certain, for example, some financial incentives were using minors' data. I can basically say that at the highest level, and I can't really get into much more detail than that. So I don't know if that is helpful, or if there's other things that you want me to touch on, Senator Maroney.
No, that is helpful. So you have an example, I guess, where you had sent someone a letter within the cure period, and I guess their violation was their privacy policies. Was that, am I understanding that correctly on the fintech? Or was
it was a non-compliant privacy policy, non-compliant opt-out process. So in that sense, there potentially could have been scenarios in which they were selling data to third parties, and so did not have appropriate opt-out processes, and missing a notice at collection.
Okay. And is that's public though? You said that letter, or
no, the letter itself is not public. We don't disclose the letters that we're sending because it's pursuant to our investigations of companies. Okay. And so there is in California, there's a FOIA exemption for investigatory files.
Okay.
But the blurb itself is posted on our website, and so it's part of our case examples, and so you can go and see that blurb and see if, I can't reveal much more, but if you want to go and take a look at how we framed that aspect of our enforcement.
That would be on there. Okay. And is that one of the only examples, I guess, then you had of enforcing what the children's provisions?
Thank you very much. I can only state that that's one of the only examples that we posted.
Public. They've published. Right. Okay.
Sitting there and doing this.
And then now the promulgation of the regs is separate from the AG's office out there, correct? So for the
regulations?
The regulations for the California AADC, is that done by your separate privacy agency, or is that your office?
No, under the AADC, the rulemaking authority is in the Attorney General's office.
Okay.
And it's discretionary. So we have the ability to promulgate regulations if that's something that, we make a determination that additional regulations are necessary. But as opposed to under the CCPA, where there was a mandatory requirement for rulemaking, and that now is shifted. All rulemaking under the CCPA has shifted to the privacy agency.
To the privacy. Okay. I don't know, and if everyone could just make sure that they're muted.
questions on all the specifics.
Linda, would you mind muting yourself? Okay. I don't know if anyone has any questions. And I guess, since we are, we don't have examples from Connecticut yet, obviously, because we're not starting to enforce our privacy.
2 more months, right?
Yeah, July 1. So I'm trying to figure out, and I had asked Michelle earlier about if we should define what willfully disregards means or give examples, but I don't want to, you don't want to necessarily tie the hands of you guys, the regulators. So if you think of anything, please send that along after. I guess I don't want to put you on the spot. Okay. And I don't know if you have any advice for us. Just last second advice you could offer.
I mean, the only advice I have is I think that it's well known at this point that this is a critical area for there to be some forms of consumer protection, because this is an incredibly vulnerable population. And, the more and more we read, the scarier it's becoming for especially parents. But, this is something that, Europe tends to lead. And so there is already, very substantial action that's happening in the UK around age-appropriate design. And there's obviously companies that are able to comply with the age-appropriate, the Children's Code, the UK Children's Code, that also do business in the United States. And so, I think it's always helpful when somebody else goes first. I know that Connecticut has often remarked that it's helpful to learn from California in terms of how to proceed with its enforcement. And we are happy to share the very important lessons we've learned in enforcement and work with our partners in Connecticut. But we do the same thing in terms of learning from our counterparts in the UK. And so, having them go first, I think provides a good amount of an understanding that if companies are able to comply there, then they should be able to comply here.
Yeah, thank you. It's a good point. Now, one last question I'm going to ask. So you have had this standard in, right, that between age 13 and 16, you can't provide, the targeted advertising or the sale of data without opt-in consent. Has that required age gating of the internet in California?
I mean, not that I could see, right? Like in terms of I haven't seen the internet prompt age gating in terms of website design. But that's a great question. Maybe we should be taking a stronger look at that.
Okay. No, because that's the argument that if we put that in effect, you're going to have to age gate the internet, everything. But I haven't heard of it, California being age gated, right? But then again, all of my friends are my age above. Well, I guess my nephews out there are, and niece would be on there, but they wouldn't notice.
Yeah, or they could, default to providing high privacy protections for all consumers as opposed to age gating.
Correct. So great. Stacy, thanks so much.
Sure thing. Thank you very much. Have a good weekend and good rest of your day.
Thanks. You as well.
Bye.
Bye. Okay. Next, Ryan, are you ready, or Nicole?
I'm here and happy to chime in whenever you'd like me, Senator. I'm happy to defer to Nicole if she's on as well.
Okay.
I'm here. I think my comments follow up on Stacy's pretty well. It might be a natural transition. Not that I want to cut ahead of Ryan.
All right, Nicole. Why did you go, and then Ryan? So Nicole from the Five Rights Foundation. The Five Rights Foundation worked to help pass the UK age-appropriate design code, as well as California, and working in other states.
Correct. Thank you. Thank you, Senator Maroney, for having me here. Five Rights, unfortunately, is not able to take a formal position on a lot of state legislation. We're only advocating for things that are specifically UK AADC, California AADC, but this bill does have a lot of important protections for youth. So I would love to give some technical feedback without taking a formal position. First, we are thrilled that it recognizes the age of adulthood online as 18. And offers important protections to 16 and 17-year-olds, and also recognizes, that children of different ages have different capacities when it comes to both risky online behavior and privacy, and those sorts of things. So we think that is great. We applaud the prohibition on the unnecessary collection and processing of children's personal data, including the important protections for geolocation data and profiling. That being said, I do think that the bill could be improved in a lot of ways when it comes to strengthening protections for kids online. The first thing I'd like to talk about is the actual knowledge plus willful disregard standard. From Five Rights perspective, that is slightly better than the status quo, which is the actual knowledge standard for most of these platforms. We're not exactly sure what willful disregard means, and I appreciate Stacy's comments where she went through the likely to be access definition and how that could be instructive. The likely to be access definition that we put into the AADC is basically our attempt to flesh out the reasonable person standard. Like, is it reasonable to anticipate that children would be on your platform? And if it is, then there are certain protections, you need to take, or considerations that need to go into the design of your product. We fear that maintaining an actual knowledge standard permits platforms to benefit from inferences they're making about user age without prioritize and allows them to prioritize profits without taking into account foreseeable risks of harm to children. And so we would advocate for a stronger standard there. The second place where I see that the bill could be improved is that when it comes to the permissible purposes for which a platform can use a child's personal data, the bill seems to allow disclosure of a reason that's not necessarily connected to providing the service. And that is a loophole, I think, that we've seen with the CCPA as well. And so we would tighten that up for kids. Any use or processing of personal data needs to be connected to actually providing the service that's requested by the child. In the same vein, the concept of consent, and I know Andrew raised this earlier, is giving me some pause, and it does in COPPA as well. It's not unique to this bill, but there shouldn't be any circumstance in which a parent or a child can consent to the use of their data that is harmful. And I don't see any clear prohibition on that. And so it would be great to see that tightened up. I'm trying to think of an example, if anyone wants an example of that. Like, we sell your personal information to data brokers in order to provide this, or your picture. How about this? Your picture and name to data brokers in order to provide you with this service for free. That could be something that could be risky. Second, requiring parental consent for under 16's use of social media. The AADC doesn't have a consent component. We don't deal with that. If states want to require consent for the use of social media, that's their prerogative. But the concern is that consent alone doesn't address the underlying harms. And so it's challenging, right? You get a parent to consent to the use of social media. I was trying to work last night and my kids kept running out, begging me to use YouTube. And eventually I gave in, right? Because I had to get some work done. And so like consent wouldn't address the underlying harms that are happening on that platform. And so Five Rights approach generally has been to make the platform safer for all. And then, as I'm sure many of you, if not everyone, is aware, there are issues with consent, especially for youth up until the age of 16. I'm not sure 16 is the appropriate age, because it could keep older teens from getting support that they need, that they can only find on social media. And that's something we saw play out with COSA last year.
What's COSA?
The Kids Online Safety Act that was reintroduced this week at the federal level by Blumenthal and I'm trying to remember the Blackburn. A few more things. I think that the bill's restrictions on profiling, they appear to be limited to decisions that may produce legal or a substantially similar effect, which ignores many of the risks that come with profiling, such as recommending certain profiles to kids or certain products. A lot of the profiling is done to maximize the engagement and keep them on the platform longer, and limiting it to things that have significant legal effect doesn't address those real harms that we're seeing play out online. And it's not often that Mr. Kingman and I agree on things, but I do think that the prohibition on using system design to extend use needs to be balanced against risk at a very basic level. Everyone designs every platform and app to be attractive and sustain use. And so we see that becoming a problem when there's harm on the other end, right? And I would hate for that provision to not be enforceable because it's too broad. So I think it's very important that it gets balanced against risk. And Andrew was correct. In California, that's part of the impact assessment. So you have to look at that, your features that you've used to engage time spent on the platform, and make sure that they're not resulting in risk of harm. I'm getting closer to the end. I think the definition of risk of harm needs to include a mental health component that doesn't appear to be in there. And that's one thing that's really, really important when it comes to protecting kids online. Not all of the harms are financial or physical. And then finally, and I realize this ship has sailed and I'm beating a dead horse here, but Five Rights generally only advocates for exemptions where there is a statutory scheme that similarly protects the privacy of user data. And so entity level exemptions are problematic because you can't guarantee that the entity is actually following the scheme they're supposed to, right? Just because you're a HIPAA covered entity doesn't mean you have to comply with HIPAA in all scenarios. Yeah. And so we try and craft things, and you'll see this in the CCPA as well, where it is a data level exemption instead of an entity level exemption for the most part. That being said, I do think that the bill includes a lot of really important privacy protections for youth and is definitely a step in the right direction.
Great, thank you. Now, would you be willing to send examples of language for adding the mental health component to the definition of risk of harm, and for how to tie the extending of use to risk? I did have one suggestion on that, but if you had anything you could send, that would be appreciated. And let me see if there are any. Does anyone have a question? I guess, what are the just the status of some of the other states who are working on age-appropriate design code clones? Do you know, are they, were you working in Maryland? But I noticed that David hadn't mentioned Maryland, so I don't know what happened there.
So Maryland stalled this year in the Senate Finance Committee. So we will make the second half of our trip to the governor next year. Okay. Minnesota is still active. It is in the Commerce Committee Omnibus, which is in conference committee right now. So hopefully we'll have an update by the end of the day. New Mexico similarly made it halfway through the process and will continue next year, but they only have a 30-day, I think, legislative session. So,
oh wow,
yeah, it was a sprint. And then it was introduced in Nevada, but did not receive a hearing in the first house.
Okay, thank you. Now you mentioned that you typically don't support the social media, so in that section, and I get it. I tend to agree that if we get the other protections right, that isn't as important. What about that section also had a piece about allowing the parents to delete? I don't know if you weigh in on that or you have no opinion on that.
Let me find it really quick.
I believe it's section 8.
And so, I'm sorry, can you repeat your question one more time? I just found it.
Yeah, so they, the one was the consent, right? You can't start at a social media account without consent. The other was on the deleting, allowing parents to delete the account.
So,
and feel free to send me an email afterwards.
Yeah.
Just thinking of this now. I don't want to put you on the spot.
Oh no, I love being on the spot. So 5 rights in all the positions we take, we try and take a child-centered approach. And I think that, one of the reasons we don't get into this area of parental consent is because that's a parent-focused approach, right? Like, not all kids have great parents. Even great parents don't have all the time in the world, and some kids don't have parents at all. So we try and do it from a child-centered approach. One comment I did have on this section, just from a technical perspective, I wasn't sure that deleting the social media account also included deleting of all of the personal information, personal data that was collected during the time that the account was active, which seems like it should be, but that wasn't clear to me.
Okay. And I'll need to reread and look at that. And then the other thing I'm just trying to figure, because we do have right to deletion in our overall data privacy. So seeing how that ties in.
Interplays.
Yeah. Yep. Okay.
But happy to send those other examples.
Yeah, if you could send those language suggestions, I would really appreciate that. Are there any other questions? Okay. Thank you so much, Nicole. All right. So Ryan, I think you're up.
That sounds great. Thank you, Senator, and thank you for having me. I think first I would say thank you to you for continuing not only to drive this working group, but to focus on this particular area. I think there's obviously an important conversation happening across the country and around the world about the unique risks of harm that the internet and technology and online services pose to kids, and existing laws that we've had on the books for some time, like COPPA, are clearly out of date. And so we appreciate this, not only this conversation, but the opportunity to be a part of it. You had asked us to I think, on among other things, our thoughts around both the actual knowledge or willful disregard standard in the children's provisions, as well as the provision regarding the duty of care to avoid a heightened risk of harm. And I think, look, others have sort of touched upon this to some extent. COPPA has obviously long had a standard in which it would apply to sites or services that have actual knowledge they're dealing with kids under 13, or sites and services that are directed to kids under 13. And I think it's fair to say that the broad consensus is that that standard is just woefully under-inclusive. I think policymakers have struggled with how to incorporate or deal with what beyond, say, actual knowledge or sites that may be specifically directed to kids. How else do you target sites or services that clearly should know that they are dealing with kids without pulling in the entire internet? And I don't know that we have a silver bullet in that regard, but I do think that the standard you've outlined, actual knowledge or willful disregard, is a fairly reasonable place to land. It's obviously not the only proposal that has, we've talked about the AADC that's out there, but I think it's a reasonable place to land. And while the term willful disregard is obviously not defined further in statute, I'm not sure how much benefit you'd get by trying to define it further in legislation. I think to some extent, terms like this will simply have to be fleshed out as case law and enforcement actions are brought to bear. But as we read it and interpret it, it would clearly, I think, at minimum, prevent sites or services from burying their heads in the sand. And if you are dealing with kids, and it's fairly obvious and you should know you're dealing with kids, then you can be and should be subject to the bill's obligations. I think as well, Section 10, which sets out the sort of duty of care or standard of care that companies should apply, irrespective, as I read it, irrespective of whether anyone has provided consent to do anything. But it also strikes me as a fairly reasonable and thoughtful provision. The term heightened risk of harm to minors is defined using concepts that have longstanding concepts that have been in American law. It refers to processing minors' personal data in a manner that presents any reasonably foreseeable risk of any unfair or deceptive treatment of or unlawful disparate impact on minors. Those are concepts that have long been in the FTC Act Section 5, in state UDAP statutes, in civil rights statutes, among other things, or of any financial, physical, or reputational injury to minors. Again, sort of referencing the kinds of concepts we've seen in whether it's defamation actions or other actions that would lie in tort, or any physical or other intrusion upon the solitude or seclusion or private affairs or concerns of minors, if such intrusion would be offensive to a reasonable person. Again, that is a clear reference to the longstanding tort of intrusion upon seclusion. And then finally, of any other substantial injury to minors. I think it's smart in order to try and articulate duties like this. I think there's value in articulating an affirmative duty like this in a statute. And I think it's smart, if you're going to do that, to articulate the duty in a way that tries to incorporate longstanding and existing concepts that most lawyers should already be familiar with in American law. I also think it is worth, particularly because we're dealing with kids and the unique harms that the internet and technology can pose to kids, that it is worth taking another hard look at the exemptions, and specifically at both the exemptions that would lie for other existing laws that are on the books. We in general have said, look, and to some extent, I think we're dealing with the challenge of in general of trying to move from a world in which in the United States we've traditionally had sector-specific or issue-specific privacy laws, And how do you transition from that kind of a patchwork to a framework which takes a more comprehensive approach? And that kind of transition can be challenging. But I do think, in general, we've said, look, if you as a policymaker decide that you need to have certain exemptions based upon existing regulatory frameworks, we think it's smart to try and ensure that those are exemptions that would apply to data rather than entities. But even if you're talking about exemptions that would apply to data, I think it is worth asking whether those exemptions are entirely necessary, particularly in a circumstance in which you're dealing with especially sensitive individuals like minors. I would then too, I wasn't necessarily planning on speaking to the consumer health data provisions, but just based upon the conversation thus far, I had a few observations that I'd be happy to share. I think, one is that one of the, as you are aware, Senator, the kind of ongoing fights with privacy legislation in general, it lies around how do you define the data that will be covered by a law? And are you going to ensure that a privacy law will in fact apply to the kinds of modern online data sets that are used to track and target people online today? And that means, of course, not just identified data or data that is stored with your name or your email address, but identifiable data that may be stored with a cookie ID or an IP address or some other form of persistent unique identifier, because whether you're talking about targeted advertising profiles or other forms of commercial online data sets, those data sets are typically stored with cookie IDs or other persistent unique identifiers and not with a consumer's name. Now, I think that the comprehensive privacy law that you passed does a good job of ensuring that it should apply to those kinds of modern online data sets. Although I think there are some things that, you could in theory do to make it even clearer and cut through arguments that you may see some raised down the road that some form of modern online data sets would not be covered by the law. I think consumer health data privacy and those provisions provide you with an opportunity to take a harder look at that question again. And we've seen this come up in other states that are considering and have considered consumer health data privacy bills. I think, among other things, you want to ensure that those sorts of bills will not only apply to identified data, but also to identifiable data, but that they will also cover scenarios like the Target pregnancy score case, which you may or may not be familiar with from over a decade ago, a case in which Target was able to identify based upon the age of women and seemingly unrelated or innocuous purchases, they were able to identify and predict when women were pregnant. And that kind of an inference is based upon other personal data that by itself would not constitute health data, but that inference that someone is pregnant would clearly constitute health data. And so you want to ensure, particularly in this space, that your bill would in fact apply to those sorts of inferences. And then the other thing
to that point, do you have recommendations on how, right? And so for people who don't know, I think that the Target case was that, why it came about was there was a teenage girl whose father found out she was pregnant because Target started sending her ads for maternity clothes or other things. It was based on vitamin purchases and other purchases that wouldn't have been considered health data. So I don't know if there's a way to draw on inferences. And feel free to send that along, because obviously I'm putting you on the spot. So, but thank you.
I'd be happy, Senator, to provide some ideas. I think there's also, there is a fine line between underlying data that by itself on its face does not constitute health data, but I suppose could give rise to inferences if someone took that next step. Right. But data that by itself should not be considered health data. But then if you take that next step and make that inference, then the inference clearly should. And I'd be happy to share some ideas on how you can.
Okay.
The other thing I would offer there, I would sort of echo the comments I made about taking a hard look at the exemptions as well, similar to taking a hard look at the exemptions with respect to the children's provisions. But I would also agree that, and obviously you already have the comprehensive privacy law in the books, which would require opt-in consent in order to process sensitive data, and health data would clearly be a subcategory of sensitive data. But I would agree that the consent requirement really ought to apply to the ability to process data at all, rather than specifically on whether it's being shared with, employees and those sorts of things. But I think you can take a look at the sort of data minimization piece, and ensuring that a data minimization requirement would not just apply to, say, any reason that a company has articulated for collecting the data in the first place. It would not simply apply to, sharing information with employees and the like, but would, perhaps require that any health data you are processing is done either pursuant to consent or only as necessary to provide a product or service expressly required by the consumer. So those are my comments. I'd be happy to try and answer any questions that they may give rise to.
Thank you. Does anyone have a question for Ryan, or any questions? Let me see. I don't see any hands raised. So I think, Paul, you have a question?
Yeah, I can't for some reason raise my hand, but
okay.
Again, Senator, good to see you, Ryan. Hey, I just want to add something to this part of the discussion on inferences. I think we have to be very careful and particularly in drawing conclusions as to what companies have done, and I think the facts are a little different here in certain cases. For example, it's one thing to look at a set of data, do analytics, and try to draw particular inferences about someone's health condition or diagnosis or something like that. There's a wholly other thing that goes on where if you buy, from a retail perspective, if you buy certain products, there's without any kind of inference or AI or anything happening at that level, right. There are processes to try to sell more products related to the ones you sell. There's been a lot of talk and debate about what happened years ago. It's a rather dated example, I think. And the reality is that if consumers buy shampoo, you're going to get promotions for conditioner.
Yeah.
No one's sitting there thinking about whether or not you have some kind of scalp condition. So I think, one of the things that came up in the legislation in Washington State, which I'm sure Ryan's familiar with, the My Health, My Data Act, the definitions are challenging. I think in discussions with the AG, the Washington Retailers Association and others have secured some, the AG is going to produce some guidance and some guidelines on what they mean by some of these definitions where they're ambiguous. And I think we have to be really careful about drawing conclusions about how inferences may or may not be made. I think the important thing in that issue, and I know I wasn't scheduled to present, is just that it's the concern in Washington State, and I think it could potentially be addressed here as well, is that, who's to say that like a tennis shoe isn't a product that has some relation to your health? And I think the closer we can get to definitions, such as one used in the ADPPA and in the bipartisan product in the U.S. House of Representatives, that ties it more to health conditions and diagnoses and things like that, or products or elements that go to that. That I think is an important level of precision that I would recommend be considered. And if you would like some language on that, Senator, happy to share what that definition is in the ADPPA and other thoughts on this. But I just want to be careful that not every action that occurs in the world of marketing products is based on some, hey, we know who you are, what your health condition is, or whatever. It can just be getting related types of offers. And yes, I think in that situation, there were some purchases. I think they received either a catalog or some kind of mailer.
Yeah, a mailer with the, yeah.
Of course, yeah, they got the mailer. And of course, the mailer came to home and it raised questions internally in the House. But I think I just wanted to, it gave me an opportunity to actually talk about some of this stuff. So I appreciate taking the time.
Yeah.
And Ryan, I'm not sure I have a question for you, but just, you and I have worked together a lot in the past. So I understand your points that you're making. I just want to add that additional, perspective.
Yeah, and Paul, I appreciate that. And I think you're right. I mean, there is a difference between being able to sell more of your own product, but then if you were to, we don't want people to be able to sell that information or sell those inferences to others, or we don't want to prevent the store from being able to, provide people what they want, right? And that customized experience, but also we don't want them to then sell that information out. Hey, these are our customers who are pregnant, or these are our customers. So it's how you strike that balance. So.
Yeah, it's an important distinction because I think in this instance, actually, Target was just reaching out to its own customer. They
weren't in that one.
Yeah, it was doing what effectively is considered to be first-party marketing, and so yeah, that's another important distinction. But yeah, I appreciate that, and happy to send you some additional information.
Okay, great. Thanks, Paul. And then I see Andy has his hand raised.
Do you mind, Senator, if I chime in before we jump to Andy? Or
oh, sure.
Yeah, I mean, I would just say, Paul, I don't think anything you said was inconsistent with the way I think about the issue as well. I mean, I think there is a key difference between, buying tennis shoes and then drawing an inference that someone has a particular health condition based upon other purchases. I think, I know there's been a lot of discussion about the Washington State My Health, My Data Act. I think there's frankly been a little hyperbole about, the manner in which some of those definitions could be applied. But, for instance, whether it's Target or someone else, if someone is, say, they buy unscented lotion and certain types of vitamins and cotton balls, et cetera, and you simply have that data on hand, that by itself, would not and should not constitute, say, consumer health data. But if you take it the next step and you draw an inference and say, okay, that means this person is pregnant, I think particularly living in a post-Dobbs world, most people would say, if you're going to do that, then that's health data, and that should be, if we're going to have a health data privacy bill, that should be subject to certain protections. But I do think, I agree 100% that there is a line that has to be drawn between, the underlying data points themselves and then taking the next step of drawing an inference like that. And so I agree wholeheartedly that we need to be mindful and careful about how the law does that.
Yeah, I think, thanks, Ryan. I think the problem is just the term inference. It's conclusory. It's suggesting that there's some motivation that you're trying to develop a profile, and it could just be that, retail is a volume business. You have to, continue to grow by getting repeat business. And so it's age old sort of marketing predates the internet by centuries, that someone comes in and likes, cherry pies, that the next time they walk in the store, if you offer them cherry pies because they're there. That's some of it. I'm not trying to minimize it, but just, inference is a strong suggestion that there's something else going on towards what Senator Maroney was saying, which is, you're developing a profile so you can sell that information. They can be targeted for other things. And I think there is this sort of area of first party marketing that is beneficial to consumers, is not meant to be nefarious. I think, but I understand what the concerns were, obviously, with the Target situation. And I'm just urging being careful and precise in definitions here, and trying to avoid some of the discussion that we saw in Washington State. I think the AG, I'll end with, I think the fact that the Attorney General's office staff have offered to provide guidance is indicative that they agree that there are some concerns with the ambiguity in the language, and that they will be providing that. So rather than have to go through that route in Connecticut, if we can have that precision up front in the statute, you wouldn't necessarily need extra guidelines to explain what the language was intended to mean.
And I guess what I might add there, Paul, is that I'm not sure I agree that the term inference by itself necessarily connotes anything nefarious. In fact, I think it's arguably already implied in privacy laws that if entities or controllers are drawing inferences about people, that's information or data. And if those inferences would otherwise qualify as personal data, they would already be subject to laws. After all, targeted advertising profiles, for instance, those don't consist of our raw web browsing data. They consist of inferences about us drawn from our raw web browsing data. And so if we're going to have those things can be beneficial to consumers, absolutely. But if we're going to have a privacy law that applies to, say, personal data or online advertising or health data, then the law has to apply to inferences. Otherwise, it's not applying to the kinds of data sets that we're talking about and that people are concerned about.
So one last thought.
I actually, we're going to move on. I appreciate this conversation.
Well, I just wanted to correct one thing, is just that when we're talking about targeted advertising, we are talking about data about your web browsing behavior collected over time across third-party websites. That's not the situation I'm talking about in a store that isn't tracking you or is sending a promotion on a product based on a transactional data they have, isn't tracking you across websites over time, developing a profile for targeted advertising. So perhaps the use of the word inference, as it is used in other laws, should be tied to the fact that it is from behavior seen and tracked over time. That's, but if your corner store coffee shop is giving you the 5th coffee free after 4 coffees, and they're tracking that, that's not the same kind of thing. They might be drawing an inference that you're a happy coffee drinker, but they didn't get it from the fact that you said that on social media or you visited a bunch of other sites. They got that from their own experience. And I think we have to protect the ability of small, medium, and even larger retailers we have to protect their ability to actually have these communications with their customers based on their direct interactions with the business, and not that aren't inferences drawn from some other behavior outside of their direct interaction with the consumer.
But what you're talking about there, Paul, just to be clear, that's not about whether it's personal data. That's about whether first party or third party collection should be subject to, say, a right. So I think that's also
I'm going to have to cut this off. I'm sorry, but we're coming up on the 1:30. I know Andy had a question, and I do appreciate that the conversation, but we're also going a little bit away. We were trying to focus more on the children's data today. So, Andy?
Yeah, I'll just be really brief. I didn't actually have a question. I just wanted to clarify a couple things. just important for us all to remember that this law is being particularly the consumer health data piece is being grafted into SB 6, right? So in terms of, an opt-in consent requirement for the processing of the consumer health data, that would already be in there because of the fact that it would be part of sensitive data, right? So that's one thing. The second thing is that I think one of the things that this fixes that is a really bad outcome of the Washington bill is that the definition of consumer health data here makes it clear that the business has to actually be using it to identify health conditions or status, right? And so that's something that would cover the use case that we've talked about here, but would avoid companies unintentionally kind of dealing in what otherwise could be construed as consumer health data. The last piece I'll just point out is that, again, because this would be overlaid onto SB 6, there already are data minimization, secondary use limitations, et cetera, requirements for the data that will be used in this law. So I just wanted to sort of bring it back to the text of the bill here and how it's actually going to work operationally. That's all. Thanks very much, Senator.
Thanks, Andy. And thank you, Ryan, for presenting. I think we've hit 1:30. We said we were going to go to 11:30 to 1:30. So I don't know. Not sure if any of the other legislators who are on want to say anything briefly, but otherwise, just, for the process, I would ask the legislators who are on to reach out to me over the weekend with any questions or suggestions. And then we will look at getting another draft of the bill out early next week. So I do see the ranking from general law. Senator Ciccarella is on. I don't know if you had any comments. And then I know Representative Carpino has been very helpful. I'm not sure if she is still on and would have any comments.
Just want to just thank everyone. It was very helpful. It's a very complicated issue and a lot of nuances. So it was very helpful. And thank you, James, you and your staff for putting this together and everybody to participate and answer those questions. I was in and out on a couple of calls, but it was helpful. And I'm sure that I'm going to have some questions, James. I'm sure we could talk over the weekend or Monday. But
I was going to try to, Sunday night for legislators, if they're interested, I'll probably set up a call. So, and then I see Christy, then Senator Huang, and I'm not sure if Rep Vahey is on as well still. So
I just wanted to say thank you. I took lots of notes, lots and lots of notes, James. So
good.
We'll make myself available Sunday night. And I just want to say thanks to everyone. This has been a long process. We still have a little bit more to go, but we've come a long way. So a sincere thank you to everybody.
Senator Huang.
Thanks, Senator Maroney. And I think a big credit needs to be given to you for kind of shepherding this, to have the experts from previous states that have kind of embarked on this as a guide is critically important. And it's also good to have the industry participate and offer their feedback. So I'm so appreciative of being a part of this and look forward to meeting up and getting the best product out there to protect the kids and make an impact. But thank you very much, Senator Maroney.
Yeah, and thank you both, Rep Carpino and Senator Huang, for pointing out, just thanking everyone for participating throughout the process. And we've gone through several iterations, and I think we'll go through one or two more iterations before we get there. But your feedback, and from, as you mentioned, the industry, from the boots on the ground, and it has been helpful in trying to make something that will provide the protections for children, but that also is workable and that you're able to comply, because if you can't comply, we really aren't providing any protections. So thank you, everyone. And we will be in touch. This will likely be the last meeting of the task force. So thank you to everyone for serving on the task force.